California has the most complex and heavily regulated rent increase framework in the entire United States. And it's not even close. If you own rental property in California, understanding the layers of regulation that apply to your specific property is absolutely critical, because the penalties for overcharging rent can include massive refunds, penalties, and attorney's fees. The governing law includes the California Civil Code, the Tenant Protection Act of 2019, Assembly Bill 1482, and dozens of local rent control ordinances that add requirements on top of state law. Let's start with the statewide framework, the Tenant Protection Act, codified in Civil Code sections 1946.2 and 1947.12. AB 1482 established California's first statewide rent cap, and it fundamentally changed how every California landlord must approach pricing. Under the Tenant Protection Act, annual rent increases on covered units are capped at 5% plus the local consumer price index change, or 10%, whichever is lower. This means that even if inflation is high, the total allowable increase cannot exceed 10% in a single year. The applicable CPI is published by the Bureau of Labor Statistics for the region where the property is located. California has multiple CPI regions, and you must use the correct one for your property's location. The cap applies to most residential rental units in California, but there are important exemptions. Units exempt from the statewide cap include housing built within the last 15 years, measured from the date the certificate of occupancy was first issued. Single-family homes and condominiums that are not owned by a corporation, real estate investment trust, or LLC in which a corporation is a member, provided the owner gives the tenant specific written notice of the exemption. Owner-occupied duplexes where the owner lives in one unit are also exempt. Affordable housing units that are already subject to a government regulatory agreement limiting rent are exempt as well. The 15-year rolling exemption for newer construction is designed to encourage development. Builders know that market rate pricing is available for the first 15 years. But once the property crosses the 15-year threshold from its certificate of occupancy, the statewide cap applies. Landlords with properties approaching this threshold need to plan their pricing strategy carefully. For properties that are subject to the statewide cap, the landlord can only increase the rent twice in any 12-month period, and the total of both increases cannot exceed the annual cap. This means you can split the allowable increase into two smaller increases if you choose, but the combined total for the year cannot exceed the cap. Now here's where California becomes exponentially more complex. Dozens of California cities have their own local rent control ordinances that may impose stricter caps than the statewide law. When both a local ordinance and the statewide cap apply, the more restrictive rule controls. Los Angeles has one of the oldest and most extensive rent control programs in the country. The Los Angeles Rent Stabilization Ordinance, known as the RSO, covers units in buildings built before October 1978 that contain two or more units. The RSO caps annual rent increases at a percentage set by the Los Angeles Housing Department, typically between 3 and 8%, depending on the CPI, though the exact percentage varies each year. For units covered by the RSO, the local cap is almost always lower than the statewide AB 1482 cap, meaning the RSO controls. The RSO also includes provisions for additional increases based on capital improvements, rehabilitation, and increased operating costs. Landlords can petition the Rent Adjustment Commission for increases above the annual cap when they can demonstrate qualifying expenditures. The petition process requires detailed documentation and is subject to tenant review and challenge. San Francisco's rent control ordinance covers most units in buildings built before June 1979. San Francisco's annual allowable increase is typically tied to 60% of the CPI increase for the San Francisco, Oakland, Hayward metropolitan area. The resulting percentage is usually quite low, often between 1 and 3% annually. For San Francisco landlords, the local cap is significantly stricter than the statewide cap. San Francisco also has a complex system for capital improvement pass-throughs, operating and maintenance expense pass-throughs, and utility pass-throughs, each with their own application process, documentation requirements, and limitations. The San Francisco Rent Board administers these processes and reviews tenant challenges. Oakland's rent adjustment program covers units in buildings built before January 1983 with 3 or more units. Oakland's annual allowable increase is set by the Rent Adjustment Program based on the CPI and is typically in the range of 1 to 4%. Oakland also has provisions for capital improvement pass-throughs and hardship petitions. San Jose's apartment rent ordinance covers units in buildings built before September 1979 with 3 or more units. The annual allowable increase is typically 5%, though the specific amount is set annually. San Jose's program includes provisions for banking, carrying forward unused increase capacity to future years, and for petition-based increases above the annual cap. Berkeley's rent stabilization program covers most units built before June 1980. Berkeley's annual allowable increase is set by the Rent Stabilization Board and is typically among the lowest in California, often between 1 and 2%. Berkeley's program is one of the most restrictive in the state. Santa Monica, West Hollywood, Beverly Hills, East Palo Alto, Mountain View, Richmond, and numerous other California cities each have their own rent control ordinances with their own specific caps, exemptions, and procedures. A landlord who owns properties in multiple California cities may be operating under completely different rent increase rules for each property. The critical first step for any California landlord is to determine which regulatory framework applies to each unit. Is the unit subject to local rent control? If so, which ordinance and what's the current annual cap? If the unit is exempt from local rent control, is it subject to the statewide AB 1482 cap? Or is it exempt from both? Getting this analysis wrong can result in overcharge liability that compounds over time. Now let's talk about the notice requirements, because California has specific rules that depend on the size of the increase. Under Civil Code Section 827, if the rent increase is 10% or less of the lowest rent charged during the preceding 12 months, the landlord must provide at least 30 days written notice. If the increase exceeds 10% of the lowest rent charged during the preceding 12 months, the landlord must provide at least 90 days written notice. This distinction creates a practical incentive to keep annual increases at or below 10%, not only because the statewide cap limits most increases to that level anyway, but because exceeding 10% triggers the longer 90-day notice requirement. For units subject to local rent control, where the annual cap is typically well below 10%, the 30-day notice usually applies. The notice must be in writing and must comply with specific service requirements. Acceptable methods include personal delivery, substituted service plus mailing, or posting and mailing if personal service and substituted service are not possible. The notice must clearly state the new rent amount and the effective date. Using incorrect service methods can invalidate the notice. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. At renewal, the landlord must provide the applicable notice, 30 or 90 days depending on the percentage, and the increase must comply with the applicable cap. The increase at renewal cannot exceed the cumulative allowable increases for the period since the last increase. You cannot save up multiple years of unused capacity and impose them all at once under the statewide cap. Though some local ordinances do allow limited banking, here's an important detail about how the statewide cap works at the beginning of a new tenancy. The cap applies to increases during a tenancy, but the initial rent for a new tenant is not restricted by the statewide cap. This means that when a unit is vacated and a new tenant moves in, the landlord can set the initial rent at any amount the market will bear. The cap then applies to subsequent increases during that tenant's occupancy. However, and this is critical, For units subject to local rent control, the rules on vacancy pricing vary dramatically. Some local ordinances allow vacancy decontrol, meaning the landlord can reset the rent to market rate when a unit is vacated. Others do not. San Francisco, for example, allows a limited vacancy increase under certain conditions. Berkeley has restrictions on vacancy increases. Each local ordinance has its own rules, and landlords must verify the specific provisions that apply to their property. Now let's cover the restrictions that apply to all rent increases in California. Rent increases cannot be retaliatory. California has one of the strongest anti-retaliation statutes in the nation under Civil Code Section 1942.5. Landlords cannot raise rent in retaliation for a tenant exercising any legal right, including making a repair request, filing a habitability complaint, reporting code violations, exercising the right to repair and deduct, participating in a tenants organization, and exercising any right under California law. California's anti-retaliation provision creates a rebuttable presumption of retaliation if the landlord takes adverse action within 180 days of the tenant's protected activity. 180 days, 6 full months, is one of the longest presumption periods in the entire country. Any rent increase delivered within that window after a tenant's complaint carries an automatic presumption of retaliatory motive. The landlord must then demonstrate that the increase was motivated by legitimate business factors entirely unrelated to the tenant's complaint. The consequences of a retaliatory rent increase in California are severe. The tenant can recover actual damages plus statutory penalties, and in egregious cases, punitive damages and attorney's fees. The finding also invalidates the increase itself and can undermine the landlord's credibility in any related proceedings. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and the California Fair Employment and Housing Act, found in Government Code Section 12955 and following, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, sexual orientation, gender identity and expression, disability, familial status, marital status, age, ancestry, genetic information, military and veteran status, primary language, immigration status, or source of income. California's anti-discrimination protections are among the broadest in the nation and include numerous categories beyond the federal floor. The source of income protection is particularly significant for rent increases. A landlord cannot raise rent specifically to push out a tenant who receives Section 8 vouchers, CalWORKs benefits, Social Security, or other lawful income. A rent increase that appears targeted at subsidy recipients, while other comparable tenants are not similarly affected, can result in a discrimination complaint with the California Department of Civil Rights and significant liability. California's just cause eviction protections under AB 1482 also interact with rent increases. Because landlords cannot terminate a tenancy without just cause, for tenants who have been in the unit 12 months or more, a massive rent increase designed to force a tenant out could be challenged as a constructive eviction or as a violation of the Tenant Protection Act. Courts and tenant advocates scrutinize increases that appear designed to circumvent just cause protections. From a practical standpoint, California has the largest and most diverse rental market in the United States, with dramatic variation between regions. Los Angeles is the largest rental market in the country by total number of rental units. The market ranges from ultra-luxury properties in Beverly Hills and Malibu to workforce housing in the San Fernando Valley and South Los Angeles. The RSO covers a massive portion of the city's rental housing, and landlords must navigate both the local ordinance and the statewide cap. The interaction between these two layers creates significant compliance complexity. San Francisco has some of the highest rents in the nation, driven by technology, including the Silicon Valley commuter market, healthcare, financial services, and a constrained geography. The city's rent control ordinance limits annual increases to percentages that are typically well below what the market would otherwise bear, creating a substantial gap between controlled rents and market rate rents for comparable units. San Diego has a strong rental market driven by military, including Naval Base San Diego, Marine Corps Base Camp Pendleton, and numerous other installations, biotech, tourism, and healthcare. San Diego does not have local rent control, so the statewide AB 1482 cap applies to covered units. Military tenants' BAH rates are among the highest in the country for the San Diego area. San Jose, Oakland, and the broader Bay Area each have their own local rent control programs with distinct rules. Sacramento has experienced dramatic rent growth driven by population spillover from the Bay Area, state government employment, and healthcare. Sacramento does not have local rent control, so the statewide cap controls. Fresno, Bakersfield, Riverside, and the Central Valley and Inland Empire communities have more affordable markets that have seen significant growth as residents have been priced out of coastal California. These markets generally don't have local rent control, and the statewide cap applies. One critical best practice for California landlords: determine the exact regulatory status of every unit you own before implementing any rent increase. Is the unit covered by a local rent control ordinance? If so, which one and what's the current cap? If not, is it covered by the statewide AB 1482 cap? Or is it exempt from both? This analysis must be done unit by unit, not property by property, because different units in the same building can have different regulatory statuses depending on their age, type, and ownership structure. Another critical best practice: track the annual CPI numbers and the applicable local cap percentages each year. The statewide cap and most local caps are adjusted annually based on CPI data. Using last year's cap for this year's increase can result in an illegal overcharge. Bookmark the California Department of Consumer Affairs website and your local rent board's website for annual cap announcements. For landlords with units approaching the 15-year threshold from their certificate of occupancy, plan your pricing strategy around the transition from exempt to covered status. Once the statewide cap kicks in, your ability to raise rent freely disappears. Some landlords adjust rents to market rate before the threshold is reached to establish a higher base rent before the cap applies. This is legal as long as the unit is still genuinely exempt at the time of the adjustment. For landlords who own units in multiple California jurisdictions, maintain completely separate compliance procedures for each jurisdiction. The caps, notice requirements, petition processes, and exemptions vary from city to city, and a one-size-fits-all approach will result in violations somewhere in your portfolio. California also has specific requirements for manufactured home community lot rents under the Mobile Home Residency Law, Civil Code Sections 798 through 799.11. Manufactured home park lot rent increases have their own notice requirements, content requirements, and procedural rules that differ from standard residential tenancies. For California landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority in addition to complying with the applicable rent cap, whether statewide or local. The housing authority evaluates whether the proposed rent is reasonable, and the increase must satisfy both the housing authority and the applicable cap. California requires landlords to return the security deposit within 21 days of the tenant vacating. The landlord must provide an itemized statement of deductions along with copies of receipts. California limits the security deposit to 2 months' rent for unfurnished units and 3 months' rent for furnished units. Failure to comply can result in liability for up to twice the deposit amount in bad faith cases. While these rules don't directly regulate rent increases, California's detailed deposit procedures require careful attention. One final consideration: California's rent regulation landscape continues to evolve. The legislature considers new tenant protection bills every session. Local ordinances are updated regularly, and court decisions interpret existing law in ways that affect landlord obligations. Staying current on both state and local law changes is not optional. It's a requirement for operating lawfully in California. Working with a California landlord-tenant attorney who specializes in rent regulation is essential for any landlord with a California portfolio. For the complete guide to California rent increase laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel. You've just completed the most comprehensive rent increase law series on YouTube.